So as I say, thank you so much for joining us this afternoon for today's webinar. So as Stuart mentioned, I am a partner in our Foreign and Travel Law Department at Digby Brown, and I specialise in accidents abroad. And we thought it might be helpful to provide you all with a bit of information about the type of work that we deal with in the department. So what I'm going to cover today is the main categories of cases that we predominantly deal with, and provide you with some information about the legal issues that can arise and how we pursue these cases in Scotland. What I would say is this is very much intended to be an overview. In the space of an hour, it's impossible to go into too much detail with each of these categories of cases. But hopefully this will be helpful for you if you do have clients involved in accidents abroad, so you know the types of cases that can be brought in Scotland and the types of situations where your clients may be able to bring the claim here. And if you are part of the network, you know the types of cases that we can help with at Digby Brown that could be referred on to us. So the key cases that we deal with are on the screen, hopefully for your slides. So we will represent Scottish nationals injured abroad. That will often be, for example, workplace type accidents, maybe sporting accidents as well. We also deal with a lot of package holiday claims, and I'll talk a bit about that. Cases relating to accidents in the course of air travel, which is governed by the Montreal Convention, and maritime cases, which is governed by the Athens Convention if it involves a passenger. I will just mention here that we also represent foreign nationals injured in Scotland, and that could be foreign nationals that reside in Scotland or foreign nationals that are injured whilst on holiday in Scotland. So across the department, we have solicitors and paralegals that speak, I think it's 11 languages that we cover across the team. So that's a service that we're really proud to provide, that we can help foreign nationals and assist them in speaking with them in their own language. For example, we have quite a large Polish unit where we have lawyers and paralegals that can help Polish nationals injured in Scotland. So this is quite a large percentage of our work as well. If a client, or we don't have someone who can assist a client in their own language, then we will instruct interpreters and translators to assist. I would also mention here that when we are representing foreign nationals who are injured on holiday, there can be some additional complexities involved in those types of cases. So, for example, their damages may be subject to tax in their own jurisdiction, and that's something that we just need to be aware of. So, in terms of accidents abroad, I'm going to talk about those types of cases. First of all, so the first thing that we need to consider when we're dealing with an accident abroad is in what circumstances can we sue in the Scottish courts for injuries sustained in another country, so jurisdiction. This has changed somewhat post-Brexit, and jurisdiction is now governed by the domestic law rather than EU instruments. So the Civil Jurisdiction and Judgments Act 1982 provides the basis upon which we can pursue a claim in Scotland relating to an accident abroad, and I've listed them on the screen there. So domicile of the defender, quite often this will be the basis upon which we can establish jurisdiction in workplace cases, and it's relatively straightforward. If the defender has a place of business, branch, agency or other establishment in Scotland. So this would be a case, quite often we'll find that Scottish nationals who work in particular industries, their contract of employment might actually be with a foreign company. and a company that's not or registered or has a place of business in Scotland as such, but they might have an office in Scotland that arranges all the clients' travel and various other types of arrangements. So you can make an argument that they have a branch, agency, or other establishment in Scotland and sometimes establish jurisdiction that way, but these arguments are not straightforward. Another one that we rely on regularly is if you are looking to bring the claim against multiple defenders. If one of them is a Scottish defender or domiciled in Scotland, then you can bring in the other parties to the action, even if you don't have they are not based in Scotland. Consumer contracts. In consumer contracts, where the defender pursues commercial activities in Scotland and directs those services to Scotland, we can bring the claim here if the consumer is domiciled in Scotland. There are probably more cases that we can bring in terms of establishing jurisdiction with regards to consumer contract, but one of the difficulties is enforcement of these actions. That has also changed quite a bit post-Brexit, so just a word of warning there. And also, sometimes these cases will be governed by Rome 1. So I'm going to come on to talk about the applicable law shortly, but the applicable law is not always straightforward to determine in these cases. It depends if you're going to proceed as a breach of contract or as a delict case. If there's a contractual clause in, for example, a contract of employment, that may be a way to establish jurisdiction. And also, if the defender submits to the jurisdiction of the Scottish courts, it doesn't happen too often, but it is there. And I just tagged on at the bottom, sorry, this was a last minute addition, but there is also the Consumer Credit Act. We don't rely on this too often, but in theory, you can establish jurisdiction if your client has, for example, purchased an excursion whilst on holiday with their credit card. If a certain criteria is met, you may be able to bring the claim against the credit card provider and establish jurisdiction that way. It's not commonly used, but it is an option available for Scottish nationals injured abroad. So once you're satisfied that you have jurisdiction in Scotland, the next thing to consider in cases involving an accident abroad is what law will apply to the claim. Now, this is governed by Rome 2 that has been incorporated into UK legislation post-Brexit. And the basic rule is the law of the country in which the damage occurred will be the law that applies to the claim. So if it's an accident in Spain, the general rule is Spanish law will apply to the claim. And as I say there, in personal injury cases, this means the country where the injury was sustained. There are two exceptions to that general rule. So the main exception that we see and that we would apply is if the person injured and the defender both have their habitual residence in the same country, then the law of that country shall apply. So using the example of an accident in Spain, if that was a Scottish national employed by a Scottish company, contracted to work in Spain, then despite the fact the accident was in Spain, you can engage this exception and Scottish law will apply. There is also, in certain situations, an argument where it's clear from all the circumstances of the case that the delict is manifestly more closely connected with a country. The law of that country shall apply. This is quite a high bar, not one that we see being argued or applied regularly. There was a Court of Session decision, I think in December, where this argument was pursued unsuccessfully. But it's there and it can, in certain circumstances, be worthwhile advancing that. What is important when you're thinking about the applicable law is to consider what aspects of the case does the applicable law govern. Now, I've listed those on the screen there. I won't go through them all. I would say in the context of personal injury, I mean, they're all important, but the main ones you want to be aware of are, of course, liability, including the division of liability, um, the existence, nature, and assessment of damages. So if a foreign law is applying, it will be what heads of claim are legally recoverable under that law, and the quantification of the damages will be assessed with reference to that law, and also prescription and limitation. This one is really important because every country, in my experience, seems to have different rules relating to prescription and limitation. It should never be assumed that that's the same as Scots law. There can be different rules relating to that. So it's just an area where you need to be really careful because it's easy to slip up in relation to that. Another point that I would make on the applicable law is that if you, for example, bring a claim in the Court of Session, the Scottish courts will presume that the foreign law is the same as Scottish law unless proved otherwise. So if you're bringing a claim and the accident was in Spain and none of the exceptions apply, you would have to bring into the pleadings, if you wanted to, an argument that Spanish law applies and what Spanish law is. And this is important because it may actually be in your interest, or your client's interest, I should say, depending on the circumstances and what law or what the foreign law is, to argue that. If both parties stay silent, then the foreign law will be presumed to be the same as Scottish law. But you could use that if for example, it was Italian law. Generally, damages are generous under Italian law, so it may actually be in your client's interest to make that argument, because they would receive more compensation than they would if Scots law applied. But equally, a defender might want to introduce the foreign law if it's in their interest to do so. So the point here is you must get advice from a foreign lawyer about what the applicable law says in terms of liability, quantification of damages, and so on. So we regularly work with and instruct foreign lawyers to provide us with reports. And ultimately, in cases that do go to court where a foreign law applies, the foreign lawyer would be required to come and give evidence. One final point I would make in relation to applicable law is that it does not apply to procedure or laws of evidence. So a claim brought in the Court of Session, for example, will be governed by the procedure of the Scottish courts. So I'm going to move on. As I say, we're really just touching on the basics in all of these areas. It's just not possible to go into too much detail. So I'll move on to the package holiday regulations. And this represents a large proportion of our accident abroad work. The regulations are underpinned by contract law and consumer rights legislation, and they're very much operated on a consumer-focused basis. The majority of the cases that we see in terms of the regulations will be, occupiers liability type cases, but also food poisoning and character. We occasionally see RTAs on transfer, and so on. So when someone is involved in an accident on holiday and they come and say that they purchased a package, the first thing that needs to be considered is, have they actually purchased a package holiday? And this is all stipulated by the regulations. So in simple terms, in order for the package holiday regulations to apply, you must have at least 2 different types of travel services, and they must have been combined in a particular way. So step 1 is to identify the travel services involved. So it must be 2 of the following: transport, accommodation, rental of motor vehicles, or any other tourist service not intrinsically part of the above. So generally that might be if they purchased an all-inclusive package or certain excursions and so on. So depending on what they have booked, you can work out whether it involves the relevant travel services for the package holiday regulations to apply. But for most people, that will be their flights and accommodation. The second step is to show that at least two of the travel services were combined. Now, I would say that this is quite straightforward to do now, following the introduction of the 2018 regulations. It used to be a bit more tricky, but these regulations, the purpose of them was to try and widen the scope for the cases that could be brought in terms of the package holiday regulations. So, for example, to show that the services were combined, it would be purchasing them by a single trade or combined by a single trader, offered, sold, or charged at an inclusive total price, advertised or sold under the term package or a similar term, combined after the conclusion of a contract, and purchased from a single point of sale. So once you're satisfied that the regulations apply to the case, the next thing to consider is whether or not your client actually has a claim in terms of the regulations. And again, this is a bit different to what we're used to in normal negligence cases that we see in Scotland. So in terms of the regulations, the organiser is liable for the improper performance of the contract, and it is an implied term of any contract that it be performed with reasonable skill and care. What's worthwhile knowing is that the organiser, so that might be, for example, Jet2, TUI, whoever the package provider is, they're liable regardless of whom they delegate performance to of those obligations or travel services to in practice. So even if it's a third party that's providing these services, as long as it forms part of the package, the organiser will remain liable. But what is tricky in these cases is often assessing what is reasonable skill and care, because the standard of reasonable skill and care is that set up by the local standards in the country where the accident occurred. So again, in these types of cases, we require the assistance of foreign experts to prepare reports and advise us on the local relevant standards that apply. So the standard of care to be applied to the services provided by a foreign supplier are the standards applicable in the relevant country. And to be successful in liability, a pursuer will need to show a breach of the local standards caused the accident. Where I think people sometimes get a bit confused in terms of the package holiday regulations is that it is local standards what's relevant is the local standards, and that's what we need to consider. And that's not necessarily the same as the applicable foreign law. So there is a distinction to be drawn in these cases between the application of local law and the use of local safety standards in determining whether or not the standard of care has been met. So really the key in these cases is instructing the right type of expert to assist you. And that might not always be a lawyer. They might be able to help you find the right expert. But for example, if the accident relates to a slip in a hotel, it might not actually be a lawyer that can advise you on what the relevant standards are that would apply to that case. There is some legal authority that says that if there's no specific technical or regulatory provision to be identified as a local safety standard, then the court may have regard to customary or general standards which may be derived from local law. So it's not irrelevant, but it really depends on the facts of the case, what standard is going to be relevant and whether you need an expert, a technical type expert to comment on the health and safety standards in Greece, for example, or a lawyer to provide some advice on the local law. So moving on again, so the Montreal Convention, we deal with a lot of cases that fall under the Montreal Convention. I've listed some of the key concepts here because you could have probably a whole day's conference on the Montreal Convention alone and still not cover everything. But generally speaking, what you need to know is that strict liability applies if a certain criteria is met, and that is up to a maximum sum of money. It's an exclusive remedy for passengers. It does not apply to employees, and it has a strict 2-year time bar, and there are no exceptions. So I'll talk a bit about the Montreal Convention just to give you some information about how it operates in practice. It regulates international carriage by air. It has its own self-contained jurisdictional regime, which is arguably quite generous in terms of being able to establish jurisdiction in Scotland. They're listed on the screen. I'll not go through them all, but generally speaking, if we have a claimant with their permanent residence in Scotland, as long as the carrier in question operates from an airport in the UK, we can bring the claim in Scotland. So that can be quite far-reaching. I mentioned that an element of strict liability applies if a particular criteria is met, and that is governed by Article 17. And Article 17 provides that the carrier is liable for damage sustained in the case of death or bodily injury of a passenger, upon condition only that the accident which caused the death or injury took place on board the aircraft or in the course of any of the operations of embarking or disembarking. So if you meet this criteria, then the carrier is essentially liable to compensate your client up to a sum of money. But unfortunately, it's not that straightforward. And I'll touch upon each of these. I'm going to sort of go in reverse actually and talk just very briefly about where the accident took place. So on board the aircraft, self-explanatory, but where we can sometimes see arguments or disputes in these cases is if there's any uncertainty as to whether or not the pursuer was embarking or disembarking the aircraft. And there are many court decisions over the years, international decisions, where this is being explored. In very simple terms, the court take the approach that whilst a passenger is effectively under control of the airline, i.e. the airline is directing where they go and what they can do, they will be in the process of either embarking or disembarking, depending on where the accident happened. I've also seen it referred to as the gate-to-gate principle. So generally, if someone's past the point where they've had their boarding pass checked, they're probably in the course of embarking the aircraft. And on the other side, once they've landed in their destination, for example, once they're through to the point where they can collect their luggage, they've likely disembarked the aircraft. But every case is different, and depending on the facts, you may have an argument that even although they're not within that window, if you like, they are still under the control of the airline. But as I say, there's a lot of authority on this, and I'll not go into it in too much detail, but it's just something to be aware of. So what is an injury? Again, this is an area that is subject to a lot of judicial commentary internationally. So death or bodily injury, so a physical injury, is regarded as an injury in terms of the convention, and you can claim. If it's a psychiatric injury alone, you cannot claim. So if it's a psychiatric injury, you do not have a claim in terms of the convention. If there's a physical injury giving rise to a psychiatric injury, generally, yes, you can claim. But if it's a physical injury with concurrent psychiatric injury, it's less clear. We would always try, but you might find that that is disputed by the opponent. So these, again, I'll not go into all the detail of it. There is a huge amount of litigation in the US relating to this area, with lawyers trying to argue that psychiatric injury causes physical changes to the brain, so that amounts to a physical injury. So it can become quite a complicated area, depending on what's happened. But you also have to consider what is regarded as an accident, and generally speaking, the convention does effectively have its own definition as to what amounts to an accident in accordance with the convention. So this, again, has evolved through the case law. And this is a case from the US, Air France, where this is a commonly accepted definition of an accident in convention cases. So an injury caused by an unexpected or unusual event or happening that is external to the passenger. But what does that mean? And it really depends on the facts of the case, if you can meet that definition. Some cases are more straightforward than others. Another way of perhaps thinking about it is where the injury is categorised as the passenger's own internal reaction to something, and it's to the usual, normal or expected operation of the aircraft, it will not be an accident and liability will not attach. So to give some examples, there's been a lot of litigation relating to passengers developing deep vein thrombosis when travelling. And the courts have held that that is not an accident in accordance with the convention because that is the passenger's own reaction, internal reaction to flying. And then thinking about what is regarded as usual, normal, or the expected operation of the aircraft, for example, light turbulence. That's expected when you travel. So even if you're injured during light turbulence, you would not meet the definition of an accident and you cannot claim. So it really depends on the circumstances. There have been some decisions recently that have been less favourable to pursuers, but you just have to consider it on a case-by-case basis. And there, as I say, there's a lot of judicial commentary across the globe of the Montreal Convention. So more often than not, you can find some cases that will be similar to the facts of your client's case that might help you with this assessment. So as I mentioned, if you get to that point where you have a bodily injury, an accident in terms of the convention's definition, and it took place either on board the aircraft or in the course of embarkation or disembarkation, the carrier, the airline, will be liable up to a certain sum of money, and that is effectively strict liability. You don't have to prove negligence in the way that we are all used to. But there is some limitation on that. So the convention's aim is to provide protection to consumers, but also to try and balance the interests of consumers and also airlines. So in an attempt to do that, there are situations whereby the carrier can seek to limit their liability in certain circumstances, and this is governed by Article 21. So if the value of a claim exceeds the limit, which is about 150,000 special drawing rights, the carrier may be able to limit its liability in certain situations. So the carrier will not be liable for damages above that, if they exceed that limit, if they can prove that such damage was not due to the negligence or other wrongful act or omission of the carrier or its servants or agents, or such damage was solely due to the negligence or other wrongful act or omission of a third party. Now, what I would say first of all is that if the carrier wishes to rely upon Article 21, then that effectively shifts the burden of proof. So it's for them to prove that they should not be liable and for meeting the requirements of Article 21. It's only really going to be relevant in higher value cases and entirely depends on the circumstances of what happened. We did have a case that went to the Inner House a couple of years ago dealing with this issue, and in that case our client was being assisted by a member of assistance personnel. He was wheelchair bound, and the argument was whether or not the member of assistance personnel was an agent or servant of the carrier. And the Inner House of the Court of Session held that essentially, if a service being provided is in furtherance of the contract of carriage, then that person providing the service is a servant or agent of the airline, and we were successful with that case. But again, it's all very fact specific, so just something to be aware of if you are dealing with these types of cases at all. They can get complicated quite quickly. And I'm going to touch very, very briefly on the Athens Convention. So this is not to be confused with accidents at work on fishing vessels. That's a different area. So the Athens Convention, it does not apply for employees. Again, there's an element of strict liability for shipping incidents up to a certain sum of money. And when we're talking about shipping incidents, that's defined as, for example, capsizing or ships colliding, explosion or fire in the ship, and so on. So if that applies, you would have an element of strict liability. If it's a non-shipping incident, so an example might be a passenger on a cruise ship trips on something, then effectively the normal negligence rules apply for assessing whether there would be liability in terms of the Athens Convention. Similarly to the Montreal Convention, it is intended to be an exclusive remedy for passengers, or, well, it is an exclusive remedy for passengers. So either your case falls within the Athens Convention or it doesn't. And if it doesn't, you don't have a claim. There's a 2-year limitation. And again, it's you've got to consider the question of embarkation to disembarkation as well to determine whether the Athens Convention applies. And it doesn't apply to marine terminals, for example, quays or port installations. So yeah, I mean, we see most of the cases we'll see in terms of the Athens Convention generally tends to be cruise ship type incidents. So we don't have too many of those, but it just depends. What I would mention in terms of everything I've discussed, particularly with regards to the Montreal Convention and the Athens Convention, is that there can sometimes be confusion in these cases because often someone has also purchased a package. So they might have purchased a package with TUI, for example, and they have an accident whilst on the aircraft. But it would be, the claim would be properly directed in terms of the Montreal Convention. That is the exclusive remedy. So just important not to get confused between these because that can also happen. And you could, without meaning to, time bar the case because the Montreal Convention and the Athens Convention, as we know, have a shorter limitation period. Whereas the package holiday regulations, I should say, that is a 3-year limitation that applies to those cases. And so, just checking time, I'm actually fine. I have been asked, we just mentioned World Cup, obviously it's coming, everyone's talking about it. I don't know how many Scottish nationals are apparently going to the US, but maybe Stuart knows a lot, I think. And so we do need to think about whether, something does happen to any of your clients when they're there, if there might be any basis to bring a claim in Scotland whilst they're travelling in the US. And indeed, if someone's injured in the course of flying, then the Montreal Convention will apply. But depending on what happens, there may be a basis to bring the claim if it's a consumer contract, depending on where they're injured. I also noticed that there seems to be World Cup packages being sold. I'm not sure. I suppose it would depend again on the circumstances, but that may be something to look at. But mainly what I would say is that when someone is injured in the US, quite often we can enter into co-counsel type arrangements with attorneys in America. And the reason that's possible is that they legally are allowed or do fund cases in a similar way as we do. So often it'll be no win, no fee type arrangements. And so that allows us to, in certain situations, enter into co-counsel type arrangements. So we can support clients in that way, whereby we effectively do all the work that is needed done in Scotland, and we work together with an American attorney who can pursue the action in the States. in terms of limitation, it's different across all states, so it's really just something to be aware of. If for whatever reason, you're contacted by someone who has been injured whilst they're over there. And the only other area that may be of relevance to this is if there's any negligence on behalf of the match organizer. This is something actually, there's been big litigation down south relating to that. I think it was I did write it down. It was an incident, I think, in 2022 at the UEFA Champions League final in Paris. A lot of Liverpool fans. There was serious disorder and issues of overcrowding, aggressive policing, and so on. And quite a lot of the Liverpool fans were unfortunately injured. And there's been quite a big litigation down south relating to this. A decision last year issued on the question of jurisdiction that was successful. So just something to bear in mind. What I would say, obviously this is me just running through all the different categories of cases we deal with quite quickly and in quite a simple way, I suppose, because it's just not possible to go into too much detail. These types of cases can be very complicated, they can be challenging, and it is important to sort of be aware of all the different types of issues that can arise. But we're always happy to help if anyone has any questions or queries in relation to a case that relates to an accident abroad. As I say, we have a good network of experts. And these are also cases that if you do refer personal injury cases to Digby Brown, that we can help with as well. But that pretty much covers everything that I wanted to cover. I've ran through it all quite quickly. I don't know if there are any questions or if anyone has any comments.
I know I'm maybe not the expert, but I do have a question.
Okay.
I hope everyone can hear me. I've kept mute so we don't have an echo and we're in the same room here. You're talking about the Montreal Convention. They don't cover psychiatric injury. Well, why is that? Where does that come from? Is that from a historic issue, or is it just to simplify things?
I think it's probably a combination of factors. It probably does stem from what was previously the Warsaw Convention, which dates back to, I'm not even sure when, but so probably quite an old-fashioned way of approaching injuries. But the other side of it is, as I mentioned, the Montreal Convention, you're trying to balance the interests of consumers, but also airlines. So I think that when the Montreal Convention was being drafted and implemented, they did want to restrict the types of injuries that for which claims could be brought, because you might have, for example, if you think about people that are scared of flying or turbulence type situations, it might open the floodgates really in terms of the number of cases that could potentially be brought in terms of the convention. So I think it's to try and limit the scope really of cases that can be brought, but that might change. I mean, the case law that we see all the time is evolving in terms of the convention, and it has evolved over time such that, I mean, initially it was bodily injury alone, so it's changed over time such that if there's a bodily injury that leads to psychiatric injury, generally you can claim. But for psychiatric injury alone, I think it's to try and limit the number of cases that would be brought. Yeah.
Well, I don't know if anyone's put anything in the chat, but if not, I will just say thank you very much for running for taking the time. Our foreign travel team is kind of an ever-growing part of the team here at Digby Brown, so it's always good to grow a lot. Oh, there's a Q&A box there. Hold on. So listeners asked, if involved in an RTA in Europe in hire car, do you know if it is necessary to report to your UK car insurer?
Ooh, I'm not entirely sure. I mean, I would say probably yes. Well, if it's a hire car, you might not need to. I'm not entirely sure, honestly, on that one. The problem is post-Brexit, it's all changed. We actually can't bring claims in Scotland if a Scottish national's involved in an accident abroad. So my knowledge in that area is kind of, I've forgotten it all. But I can check and let you know if that helps at all.
Absolutely. if anyone does have any other questions and only thinks about them in the next hour or so, feel free to get in touch. I'm sure we can kind of go back before you more and get an answer back to you. But yeah, I just want to say massive thank you for everyone for turning up and thank you to Rona.